Welcome to the Court of History. I'm Sidney Blumenthal. The court is now in session. I'm here with my colleague, Sean Wilentz of Princeton University. Sean, I've been thinking a lot about the attacks by the Trump administration on the media. It is a full-scale assault, unlike anything ever seen before, including the Nixon era. This is almost the full, efflorescence of Nixon's darkest dreams.
Well, it's beyond anything that Nixon even contemplated, let alone that Nixon did. Well, it's part of the general attempt by the Trump regime, to disable all of those institutions in civil society that might pose any kind of threat to them. And the media obviously is right there. The Fourth Estate. I mean, and all of that. So there's a bunch of different angles about it, but there's no question that the FCC in particular has been thuggish in its retribution as far as Trump is concerned, going after his enemies. But more than that, actually trying to intimidate and corral the entire media to do Trump's bidding. That's my view of it.
Yeah, as it happens, there's a complaint that's been filed by the Freedom of the Press Foundation to the Office of Disciplinary Counsel of the District of Columbia Court of Appeals regarding Brendan Carr, who is the head of the FCC, and his various actions against media organizations. And it so happens that we have with us Seth Stern, the Director of Advocacy at the Freedom of the Press Foundation. The foundation monitors and documents virtually every press freedom violation in the U.S. and engages in advocacy to defend the public's right to know. Welcome, Seth.
Great to be here. So
this complaint was filed this July 28th. To the D.C. Court of Appeals. And you must have taken some time in thinking about the basis of submitting this as a serious matter about Brendan Carr and what he's been doing in violating the D.C. rules of professional conduct.
We did. And Brendan Carr has done a lot of questionable things during his tenure as FCC chair, but to bring a disciplinary action against an attorney, first of all, they need to be quite severe. Second of all, they usually need to relate directly to the practice of law, to the court system. The attorney disciplinary commissions aren't limited to the court system, but they're much quicker to discipline attorneys when they are impacting the legal system. And there is also sort of a reluctance, understandably to some extent, to take actions that are going to be seen as partisan or political. So those were kind of the obstacles we were concerned about. But when he approved the Paramount Skydance merger 2 days after Trump tweeted or truthed that he had received Paramount's $16 million shakedown payment with $20 million in PSAs from Skydance on the way, it seemed not only justifiable to file it as a long shot, but something that might be taken seriously. We hope will be taken seriously. We hope the commission will rise to the moment, because this isn't just Brendan Carr acting in his capacity as a regulator or asserting some novel interpretation of communications law. This is, as FCC Commissioner Gomez, who dissented, said, this is Brendan Carr using his power as FCC chair to broker a settlement of a private lawsuit for his close political ally, President Trump, that we all know is in no way whatsoever justified by the facts or the law of the case. That should be, I think, right in the disciplinary commission's wheelhouse. Attorney regulators should not want attorneys turning the courtrooms into bribe launderers.
Yeah. Well, let's step back for a minute. Brendan Carr is the author of the section of Project 2025 on media and what should be done for it. So he is acting out the guidelines of the manifesto that was created by the far right as its chief commissar. And he is a close ally, by the way, of Leonard Leo, isn't he?
Yeah.
Who is the former co-chair or the co-chair of the Federalist Society. Yeah. So tell us about Brendan Carr's mission to upend the media on behalf of Donald Trump and to bend it to Trump's wishes and to basically neuter the media from actually performing its journalistic function under the First Amendment.
Right. Yeah. And there are two ways he wants to do that, I would say. One of them is deregulation and just an acceleration of media consolidation, which is obviously a pre-existing problem, but one that he would like to expedite. And unfortunately, corporate owners of some media outlets are happy enough about his deregulatory efforts that they are willing to overlook his infringement on their journalists' First Amendment rights. I saw the National Association of Broadcasters publishing statements thanking Brendan Carr for deregulation. And whether you're happen to be a fan of the deregulation efforts or not, and I don't think that they should be one, giving this man any sort of credit while he undermines the legal rights that enable your industry to exist is, to me, misguided would be a weak way to say it. The other way Brendan Carr wants to essentially neuter the media is by stripping broadcast media, at least, which the FCC regulates, the public airwaves, of its First Amendment rights to report as it sees fit. In his view, it is the FCC's business to monitor bias, and you do not necessarily want your bias monitor to be someone who wears a lapel pin of the sitting president. That seems a bit biased. And he has taken these sort of loose legal concepts like news distortion and the obligation of broadcast licensees to operate in the public interest as permission to exercise broad powers to censor speech and journalism, which he subjectively views as outside the public interest. For example, he and Donald Trump want ICE to be able to operate in secret. That's why they, wear masks and have their lawyers not file appearances with their names on them. So he has come after broadcasters that simply identified the locations where ICE was conducting operations. Really routine journalism that he just deems outside the public interest because his boss doesn't like it. Admittedly, those public interest and news distortion standards on paper are vague, but like so many other things we've come to find out in our country, that really norms and just unwritten understandings were the glue holding things together. Everyone kind of understood that those rules or those doctrines were subject to and subservient to the First Amendment. That, of course, the news distortion policy and public interest language cannot be read as broad license for regulators to shape broadcast content because the Constitution wouldn't allow that. Those norms, those assumptions, Brendan Carr doesn't recognize them. He does recognize them. He used to say that back when he didn't control the FCC. Anytime he perceived Democrats as influencing editorial content, he would make a big, fuss about it and get on his First Amendment high horse. And that's the thing about Brendan Carr. He knows better. He was once a serious person. He's a real lawyer. He's not some political hack like, Ed Martin or other people we've seen sort of pursue these frivolous, silly investigations to get on Trump's good side. Brendan Carr is a real lawyer who was once taken seriously. He knows better. everything he's doing, he knows is illegal and unconstitutional.
Yeah. Well, the thing about it is they're not going after Fox News if you're interested in, bias and distortion. And what they define as bias and distortion is what I would define as somebody who has worked in many news organizations, such as the Washington Post, under Ben Bradley when he was editor, and Catherine Graham when she was the publisher, as journalism. That's what we would call journalism. And they are engaged in an Orwellian exercise, to say the least, simply against people they define as political enemies by reporting inconvenient truths and using forms of government control. They're hardly the apostles of limited government. They are instead weaponizing government, a favorite word of theirs, weaponize, using government to intimidate and coerce. Sean,
if I could jump in, the FCC is supposed to operate in the public interest. That's the phrase that we see all the time, that there is such a thing as the public interest. And it used to be assumed the public interest was not a particular political interest, that there was something larger than a particular political interest. What's happened is that the Trump regime has conflated their interest with the public interest. It has made them the same. It's a sort of twist on, the absolutism of l'état c'est moi, I am the state, as Louis XIV said. Well, Trump is saying, I am the country, I am the nation, right? And so if you come against me, you are by definition attacking the public interest.
Yeah, well said. And you were talking about Fox News. Initially, I think Brendan Carr's excuse for not coming after Fox News was that, the FCC doesn't regulate cable, which is true. But then Brendan Carr came after MSNBC for not airing one of Trump's press conferences. He invented the theory that the public interest requirement means that not only broadcast licensees, but cable stations are obligated to air presidential press conferences and repeat the president's false talking points, in that case, about the immigrants who are supposedly invading us from Trinidad under the control of the Venezuelan government, which, of course, was another, this time, newspaper-based news story from the Times and Post that Trump claimed was fake news until our organization, Freedom of the Press Foundation, got the intelligence community memo that corroborated everything that the Times and Post said. Sure, Fox News is biased in all sorts of ways, and we don't need to go through the whole parade of terribles about Fox News, but they're entitled to be, and that's the thing. Even if Carr had the authority to regulate Fox News, he shouldn't, nor should he regulate MSNBC, NBC, CBS. I'm not here to say that all of the stations being punished and retaliated against by Carr are perfect or never make mistakes. The whole the whole lawsuit that resulted in the $16 million bribe was over editing of the interview with Kamala Harris. So
let's talk about that CBS case, because Brendan Carr played a key role. Could you explain the role he played in that investigation of CBS on behalf of Donald Trump, what the claims were, what happened, and what the resolution was, and what the consequences are in terms of intimidation of the press?
Yeah, so CBS on 60 Minutes during last year's presidential campaign interviewed Kamala Harris, asked her a question about the war in Gaza. She gave an answer that they edited for clarity, as they routinely do, as all news broadcasters routinely do. It aired on 60 Minutes. The show's called 60 Minutes. They don't have time to air answers in full. They edit for time. There's that little clock in the background, the whole, The claim was that the editing distorted her answers to make her sound better. And that therefore they had deceived consumers, they had interfered with the election. It obviously didn't stop Trump from asserting that claim that he won the election. Even that they had unfairly competed with Trump's own media property, Truth Social. That was one of his claims. Now, if you go back and listen to the interview answers, they're both gibberish. They're both excuses for the Biden administration's inaction in Gaza that make no sense and say absolutely nothing. They're just two different sections of a word salad answer. That being said, it is not the government's or the court's place to determine whether a news station properly edited an interview, and ask any First Amendment expert in the country, and they will tell you that. The lawsuit was outrageously frivolous. I don't know of one serious lawyer who believed it was worth $1, let alone $16 million. Nonetheless,
so what did Brendan Carr do then?
Yeah.
Well, after months of negotiations and back and forth, Trump and CBS, as we all know, settled the lawsuit for $16 million. Why were they able to do that? Well, CBS, or Paramount, its parent company, had a merger with Skydance Media pending. Mergers need to be approved by the FCC. The FCC needs to transfer the broadcast licenses from, old company to new company. And it was widely reported that people at CBS believed that merger would not be approved by the FCC unless they were to pay Trump, unless they were to settle that lawsuit for a substantial amount of money. Now, of course, Trump could not credibly use the FCC approval process as leverage unless he had an FCC chair that would go along with it, an FCC chair that would withhold approval of the merger until the case was settled. And he had that chair, and that chair was Brendan Carr. Only after the settlement was announced did Carr hold a reported meeting with Skydance, the acquirer of CBS, to extract also unlawful editorial concessions. They promised to appoint a bias ombudsman and other such things that Carr has no business extracting from them. And only after, as I said, Trump tweeted out that he had received his settlement payment did Carr finally approve the merger. He could have done all of that anytime. He could have had his meeting with the Skydance folks a month ago, 2 months ago, 3 months ago, and then entirely detached the merger approval process from Trump's private lawsuit. That was well within his power to do, but he chose not to. He chose to operate on the timeline of Trump's private litigation so that Trump could use his agency's processes that are supposedly independent for bargaining leverage to extract bribes.
So he's also revived claims against NBC and ABC, hasn't he?
He has revived claims against NBC and ABC, including claims about the fact checking during the presidential debates being unfair to him, about whether there were violations of airtime requirements with Kamala Harris's appearance on Saturday Night Live. As I think you alluded to, he did not revive similar claims that had been dismissed against Fox News. Our position is that all of those claims were meritless, whether it's against Fox or whether it's against NBC, but he made a point of reviving the ones against the outlets that Trump dislikes and not the ones that, at least at the time, he liked. He's also gone after public broadcasters. He went after them on what should be a relatively minor thing, claims that their sponsorship announcements went too far and functioned more as advertisements that they weren't supposed to air. That would be a minor regulatory issue if it had any merit. But he, for no apparent reason, decided to use the letter inquiring about those issues to voice his opinion that public media should not exist. And that was complementary to the Trump administration's attacks on public media that we've seen since. So he's in any number of ways functioned as sort of a censor in chief, as some have said, and it's quite damaging. We heard recently, I mentioned Commissioner Gomez, the dissenting commissioner on the FCC, who has been very courageous in voicing her views and has gone on a First Amendment tour to sort of expose what's going on at the FCC. And she's talked about, broadcast licensees, and we're not talking about Paramount. We're talking about, small local stations telling her that they're afraid to report the truth because they don't want the FCC to come after them. It's what tax cheats say about the IRS. It's not what broadcasters are supposed to say about the FCC. The FCC is supposed to have no voice in content. So the chilling effect is enormous. And the thing with chilling effects is you never know how bad they are because you only know what news you see. You don't know what news you don't see. You don't know what ended up on the cutting room floor. So we'll probably never know quite how bad it is.
Yeah.
This attempt to go after content seems, and they want to make the media not just subservient to them, but actually parrot their own views and to keep views that are contrary to their own view. It's a lot what they're doing with the universities, tampering with the universities to make sure that certain kinds of views get expressed and that others don't get expressed. And this is really, talk about chilling. This is trying to turn the entire media into basically a trumpet for the Trump regime, which is frightening, beyond frightening.
Absolutely, and to make them pay a tax if they don't,
Right.
if they don't abide, and the
Not
idea
only
that
a tax, Seth, but a bribe.
a bribe,
Yeah.
a bribe, yes,
That's subject to the whim of Donald Trump.
Right.
Right. And when ABC settled its case arising from George Stephanopoulos calling Trump an accused rapist as accused
Adjudicated rapist, I believe.
right, as opposed to sexual abuser. And you can imagine if that case had proceeded, if Trump wants to prove damages, he's going to have to show that, somebody would have associated with him or done business with him if he were only an adjudicated sexual abuser, but they drew the line at rapist because, that's how it works. But anyway, ABC settled that case for $15 million and essentially set a market. There was widespread reporting that, the sticking point in the negotiations was that Paramount essentially wanted to settle in the same range that ABC did. They thought going too far above that range, then it would look like a bribe. Paying $16 million to file a frivolous lawsuit is one thing, but if they had paid 25, then that would have been too far from what ABC paid. Now, of course, when you're negotiating settlement of a meritorious lawsuit based on legal fees, based on litigation costs, based on risk, you're not thinking about what someone else paid in an entirely different case with entirely different facts and entirely different, laws applicable. One was a defamation case. The other was this weird consumer fraud case. The only reason you would be thinking about that is because you're paying a bribe, and the market rate for bribes was set by ABC. Now it has been set by CBS, and no question, Trump's going to go after someone else next.
Yeah, the thing about a protection racket varies. Sometimes if you just pay the money to the mafia and it protects you from breaking the windows of your storefront, let's say, you can continue to sell whatever you're selling,
Right.
as long as you just pay up. But that's not the case here. This is beyond a protection racket. They want to determine what the content is of what this company is doing. So it's beyond what the usual mafia-like protection racket would be.
Right, and Paramount gave them a perfect opportunity to do so because of the merger that Paramount desperately wanted to close, that Paramount's controlling shareholder, Sherry Redstone, had an enormous financial interest in closing, and that gave the Trump administration, thanks to Brendan Carr's cooperation, all sorts of leverage and all sorts of strings to pull. And as you're saying, it resulted not only in pay me my $16 million and then you can go back to doing your journalism. It resulted in pay me your $16 million. You need to appoint a bias monitor to police the editorial content on your network for something as subjective as bias. And you're going to need to air $20 million worth of Trump friendly public service announcements, as Trump has claimed the new owners, Skydance, have agreed to do. And as far as I know, nobody at Skydance has denied it. So, if you want to talk about First Amendment issues, now you've got essentially everyone in America being compelled by the government to watch political propaganda on the public airwaves. That doesn't.
Well, if they gain complete control, but on the other hand, what they're doing is driving out journalism, so
Yes.
that through intimidation, so that people are not reporting the stories and that they should be reporting, or hedging what they're saying, or deciding what should not be covered. And I hear it all the time from people in journalistic news organizations.
What do you hear, Sid? Give an example of the kinds of things you've been hearing.
Well, people's language has changed. The lawyers are in charge. The lawyers act like editors, and they all act on the worst case scenario of being sued and the news organizations being threatened. And the selection of stories is in part determined by, the intimidation.
Yeah.
So there's, people are, I have heard that there are stories that have not appeared yet about Trump and Epstein.
Mm-hmm.
In major news organizations. There's a lot to report there on that deep relationship. But you've got, so Brendan Carr is certainly earning his pay for Trump.
Right, and that's just one line of attack. I think you're right. There are stories being either withheld altogether, watered down, placed on page 26 when they should be on page 1. Any number of ways that this administration is impacting editorial choices, particularly by mainstream corporate outlets that either depend on the FCC for licensure or depend on the White House for access. We saw what happened with the Associated Press for saying Gulf of Mexico. But that's really just one line of attack. One place where we know news is not being reported that should be is journalists who are not citizens of the United States, even op-ed columnists who are not citizens of the United States, who are afraid to report anything with their bylines on it. And they're just, it's not just that they're watering down their stories, they're leaving journalism, particularly student journalists. So the attacks on the free press are across the board, and I would, for people who say, well, it's not that bad because I can still pick up my paper or log into, the New York Times website and see stories that are critical of Donald Trump, so all must be well, we still must have a free press. That just because it's not as bad as it can be doesn't mean it's not bad. As I said earlier, we don't know what we're not seeing.
Yeah.
Imagine how bad it would, if you think Trump's getting criticized by the press now, imagine how badly he would be criticized if the press was.
Well, one interesting thing that your complaint points out against Brendan Carr is that they're even going, he's even conducting a campaign against online organizations, including a very interesting one called NewsGuard, which is a fact-checking news organization that Brendan Carr says is violating the First Amendment. This is, consistent with the overall attack of the right wing that somehow anybody who fact checks and deals with the world of disinformation, which is also polluted with foreign adversaries and bots and propaganda, is somehow violating the First Amendment and freedom of the press. I mean, this is one of their new lines of attack. But here we are. Carr has sent letters to the CEOs of Alphabet, Microsoft, Meta, Apple, accusing them of being part of a censorship cartel, according to your complaint.
Mhm.
So he's far beyond his jurisdiction here, isn't he?
Yeah. The FCC has no role in regulating online news content, nor does it have any role in regulating cable news content. He knows that, but he is threatening to do both. And he has already shown the country that he is untethered by the law, by the limits of his own jurisdiction, and willing to investigate things he has no business investigating. So sure, when Google or Meta gets this letter, their lawyers say, this doesn't make any sense. Brendan Carr has no business regulating us, but that doesn't matter. Brendan Carr can still make their lives miserable by investigating them and throwing them and dragging their names through the mud for the next several years. So they have incentive to capitulate. And these are big corporations that don't care a whole lot about the First Amendment, and to the extent they do, they care about their bottom lines a whole lot more. And that's a problem that the administration has spotted and has seized upon in the past. I'm not here to say that owners of news outlets 20, 30 years ago were morally and ideologically pure, but to the extent they weren't, they had business interests that aligned with a strong First Amendment. They had an economic reason to go to bat for their journalists. Now, ABC's, Disney's theme parks are worth a lot more to it than its journalists are. Paramount's movie studio is worth a lot more to it than its journalists are. So the situation is really ripe for journalism and the First Amendment being thrown in under the bus to serve other corporate interests, and a weak, legally inadequate letter like the one Carr sends to online, companies, calling them part of a censorship cartel. Its legal shortcomings are besides the point. It serves its purpose of intimidating.
Can I ask a question about your strategy, just not to change the subject too much? But you're objecting. You're going after Carr, in effect, not as a public official, but as a lawyer, as an attorney. And then it strikes me that is an interesting way to think about how to fight back. That not everybody who's doing this kind of thing for the Trump regime is a lawyer, but many of them are. And to bring them to bear before the bar, if you will, is one way to point out, why the lawlessness is taking over. Attorneys ought not to be lawless, right? And that's effectively what you're saying, is that this is an attorney who is lawless, right?
Right. Look, I commend everyone who is bringing constitutional actions against this administration. That's certainly vital work. But at the end of the day, the administration gets to defend those claims with public money. And if it loses, so what? The status quo holds. When it wins, even 1 in 10 cases, then that just shows it the way. It shows it what door it can barge through. So I don't think it really bothers the administration all too much when you challenge them under principles or under constitutional claims. If you can hit someone in their pockets, it bothers them a bit more. And I don't know what Brendan Carr's future career plans are, but there's a revolving door. A lot of government regulators, after they're done in government, want to cash in. And in the case of attorneys, that is often at a big law firm where you can get a lucrative draw as a partner. But you can't do that if you don't have a law license. And Brendan Carr should not have a law license.
But it's also bringing to bear another court, if you will, which is the bar. That who's going to decide this is not going to be fellow Trump people. It's going to be the bar. And as long as the bar remains independent, then they can actually punish these people for being lawless. I mean, I think that's very strategically very, very clever on your part.
Oh, well, thanks. And I mean, yes, I think that's right. It's an organization that has not been captured yet, not for lack of trying. They did attempt to run Pam Bondi's brother for the DC bar presidency. But as of now, to the best of my knowledge, the DC bar has not been captured yet. There are sort of longstanding traditions and norms in bar associations of being somewhat hands-off, of not wanting to over-sanction and over-discipline lawyers for good reasons and bad. The good being they don't want to discourage novel legal theories, particularly coming from new lawyers representing folks without a lot of money. The bad being that the whole thing is an old boys club and they don't want to punish each other. But I would posit that those norms are products of a bygone era, and that if the disciplinary commissions in DC and elsewhere want to maintain the integrity of the law profession and the rule of law more broadly, they are going to need to rise to the moment and take some cases that might make them a little uncomfortable and get a little bit of flack for it and just deal with it, because they're one of the few lines of protection we've got left.
Well, of course, Trump and his people regard the American Bar Association as the enemy, just as they regard universities as the enemy, as major law firms as the enemy, and major media as the enemy. And they have prohibited members of the Department of Justice, staff people, from participating in any ABA events. Right. So this is the creation of a different kind of society and a full-scale assault on civil society that the ABA ought to recognize, given that it's a target as well.
Mm-hmm.
Right. And the ABA, although it promulgates the model rules of professional conduct that DC and the other states adopt, the DC Disciplinary Commission is separate and apart from the ABA. But yes, I think the ABA should be vocal about the attacks on the rule of law, as it has been to some extent. They've released some strong statements. They should, of course, say more. And to the extent that these rules can be interpreted or guidance can be issued in terms of how they can be applied to current realities, that would be really helpful. And I would encourage the ABA to think about doing that, because although they don't draft the rules that each jurisdiction adapts, they do have influence over how those rules are interpreted.
Yeah. Well, Seth, thank you so much, Seth Stern of the Freedom of the Press Foundation, for appearing with us and having this conversation about a very important question involving the Federal Communications Commission and its assault now on freedom of the press. And for the Court of History, on behalf of my colleague, Sean Wilentz, this court session is adjourned.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.